Warning. You're now entering a stream that isn't suitable for everyone. Be warned that this channel will have swearing, singing, sexual innuendos and lots of jokes that could easily offend. It is advised that you must be a little bit weird yourself to enjoy this channel, as those that thrive and enjoy the stream are weird in their own little ways. The chat is called El Chatty and is a wonderful community. It really is. However, again, it might not be for everyone. We want to hear everyone's opinion, no matter what it is. We encourage debate as long as it's done respectfully. If you're easily offended or don't like differing views, then again, this channel is not for you. By entering this stream you do so at your own risk. If you want to try it out, that's absolutely fine, but if you don't like it, no need to announce your departure, you can just leave quietly, as this isn't an airport.
Dane and Dennis walking down the street. Dane and Dennis, the kind I'd like to meet. Dane and Dennis, they used to wear these tight old thongs. They didn't like them, so they're gone. Dane and Dennis walking down the street. Dane and Dennis, the kind you'd like to meet. Dane and Dennis, these two who look at them, they're definitely growers, not showers. Dane and Dennis walking down the street. Dane and Dennis, the kind I'd like to meet, and I can't wait to go to meet these two speedos pro. See you in Boston, boys. Okay. How are we doing? I hope everyone made it over. I don't think everyone did, but I did try. People. One of those things, really, isn't it? Can't make everyone come over. Or there's to say, you can't make everyone come. Right, behave, for fuck's sake, just fucking behave. Once in your life, just fucking behave. I mean, I got 90 days to behave. Fuck. Yes, 14 people. Cheaper, is that it? Okay, 19 likes. Not many people like this then. Hey Gary, see you tomorrow, buddy. Not many people like this stream then. That's fair. That's fine. Spacey, Stacy. Colonoscopy. Stacy. I might do one with you, Stacy. I might come out and do it with you just to hold your hands. Hold your hands, Stacy. We'll do it together. Little G went to grab a bite to eat. Spacey, Stacy, I would hold your hand, sweetheart. I would hold your hand whilst you were taking a bit. Oh, I won't. That's too far. Spacey. Hey, is it ungentlemanly need to ask it? How old are you, Stacey? How old are you? I guess 22. Or don't answer me if it's not very nice of me to ask. Some people, like Daffy straight away said 73. To me, 48. Oh, okay, yeah. I mean, you got probably 2 years then. You're gonna have to do it. They say between 45 and 50. You should get your first one. 19 watching now. 19 watching. Dave Portner from Boston Sports, was he 47, 48? They found about 4 different polyps in his when he did his. and they're non-cancerous. So that's why he was glad he did it. Just go out of the way, peace of mind and everything. If you left them, they could have grown. So that's why you're gonna be fine. Um, yeah, it's between 45 and 50 this day, so you should really. Is there any history in your family of that as well? Because that is so. If you got any history in your family, especially any cancer, but especially colon cancer, then you should be gone. If you're high you can't start with a cold poop in the box thingy. You can, but that doesn't show up polyps and stuff like that, polyps or whatever you call it. So I always recommend just do it. Just do it. Just do it. Do it real good. Da 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 da. Do it real good. I just find it's done, and then for the next 5 years do the box thingy. Okay, so you got till 50 to do with Spaces Stacy. Precancerous and would have had cancer like if I had waited. Just do it. Just do it, girl. Yeah, you got polyps, so just do it, girl. It sounds scary, but it's such an easy process. And if you got polyps, bang, they take it straight out. Don't give me that shit. I just need to make that get the fuck out. And don't give me that shit. Talk about shit. Make time. Tomorrow. Arrange it. I'm only doing it because I know how much of an easy process it is, and also how the weight's lifted off your mind once you've done it. So, and you feel like so lighter as well. You're so lighter. Right, let's get into this then, because I know that people want to get this done. Right, let me just double check that there's nothing happening on the other one first. No, nothing. So fuck that then. Okay, we're here. Right. Here you go, people. Here you go. I'm going off watching it with you from the space station here.
All right, good morning.
Good morning.
Good morning. Could you please introduce yourself to the jury?
Yes, my name is Special Agent Robert Corley. I'm with the FBI Jacksonville Division.
And can you tell us just briefly about your education before joining the FBI?
Yes, I have a bachelor's degree in criminal justice and a master's degree in criminal justice.
And how long have you been with the FBI?
Since May 2011, so I'm 13 years.
Are you a full-fledged special agent, or are you in some sort of support role, or what? What's your role?
No, I'm a special agent assigned to national security investigations.
Now, you are here because you analyzed some phone records for some of the people involved in this case to see whether you could determine where they had been on the night of October 4th and the morning of October 5th, and whether their phones had made any significant movements. Is that right?
Yes, sir.
Now, what is the methodology that you used to do that?
We define it as cellular analysis. We basically look at cellular records provided by cell phone companies. We match those records with cell tower lists, which are also provided by the telephone companies. And then we use relevant dates and times provided by investigators to create a report and analyze the location of the device.
Now, did you do this in your capacity as a member of CAST?
Yes, I did.
What is FBI's CAST?
So CAST is short for Cellular Analysis Survey Team, and it is a team of approximately 80 agents and task force officers spread throughout the United States. CAST performs three primary functions. We provide training on cellular analysis to state, federal, and local law enforcement partners. We also use the methodology and the techniques we're going to talk about today to track and locate people in real time. So we'll often be asked to help locate fugitives, help locate missing children, and unfortunately, a lot of times locate missing bodies or remains of victims.
Now, can you tell us about the training part?
Sorry. And the third primary function is to do what I'm doing today, to testify as an expert witness in trials.
Can you tell us about CAST training that you got that allows you to do this sort of analysis?
Sure. So CAST training starts with a basic course, which is just an introduction to cellular records that all agents, state, local, and federal law enforcement can participate. Once that class is completed, you can be invited to what's called an advanced course, which is reserved for FBI special agents and FBI task force officers only. After advanced course, you go on to what's called field training certification, where you spend 3 days looking at prior investigations or cases. You're putting like a command post situation where they give you a time limit to solve a case and see if you can come up with the same solution that the original case agents did. And if you progress through those and you meet all the minimum requirements, you can be invited to CAST certification. CAST certification is a 4-week course. It consists of 1 week of training in RF theory, radio frequency theory. That's taught by PhD professors from the Florida Institute of Technology in Melbourne, Florida. After that, we have a week of training and interaction with the cellular providers. In my case, it was AT&T, Sprint, Verizon, and T-Mobile. Sprint, merged with T-Mobile, so now people no longer receive that training, but at the time I did from Sprint. And they bring in the people that produce these records that we're going to talk about. So when law enforcement submits a search warrant or a court order, they will provide these records. They talk about how they pull them, what all the columns mean, and then we also talk with the engineers that actually work on the towers and the networks in the field. After that, we received some training in mapping, different types of software that we use. We also received training in something called drive testing, where we take the equipment out and we do measurements of the actual footprint of the cell tower. So we can not only say what we believe the cell footprint or the cell tower footprint would be, we can, in some cases, actually map out the actual footprint of the cell tower.
And have you completed all of those steps that you just described?
Yes, sir.
And do you hold the CAS certification?
Yes, sir, since 2019.
All right, so since 2019, you've been full-fledged member of the CAS team?
Yes, I received the training, and we receive an annual recertification, which is 24 hours of training every year, generally consisting of those same things. We bring the carriers back in, they provide any updates to any of their records, and then we also receive training from other companies like Google, Apple, companies that provide other location-based services.
So aside from the training to do this type of analysis, since 2019, have you gotten experience actually employing this in cases?
Yes, I actually use this in my own cases. That's how most people become a CAST agent. You start using some of this technology in your own investigations. So I use it not only to help other agents or investigators with their cases, but I also use it daily, weekly, monthly in my own investigations.
And have you testified about it in court before today?
I have.
About how many times?
19 times.
And have you been accepted by courts as an expert witness before?
Yes, all 19 times.
Your Honor, at this time I would offer Special Agent Corley as an expert in the area of cellular analysis. Objection.
The witness is accepted as an expert.
Now, in this case, did you receive a request or perhaps a series of requests from the Savannah FBI office to conduct this sort of analysis with respect to some cellular records that they had obtained?
Yes, sir, I did.
And did you receive cell phone records from Taylor Burns of the Savannah office?
That's correct.
Did these records include a set of phone records for a number identified to you as that of the defendant, Leilani Simon?
Yes.
Did they include phone records for a number identified to you as that of her boyfriend at the time?
Yes.
Did they include cell phone records for a number identified to you as that of a brother of hers that was living in the same house during the relevant time frame?
Yes.
And did they include cell phone records for a person identified to you as the father of the missing child?
Yes.
All right. Once you had these records, what did you do with them in short?
So once I receive the records, first I do a check to make sure they're original records received from the phone companies. Nothing is out of the ordinary. And then I take the records and match them with a cell tower list. The records will provide you, in this case, we specifically use timing advance records. They provide you with the tower used, the sector of that tower used, and then the distance from that tower. So we're able to provide a general location of where a device is located. So I use those records and then produce some maps and a report showing where the phone was located during that time.
You mentioned you produced some maps. Have you for today prepared a presentation detailing your findings?
Yes, sir.
And do you believe that presentation will aid the jury in their understanding of your testimony?
Yes, very much.
Do you see in front of you a document marked as Case Exhibit 64?
Yes, sir.
Can you tell us what that is?
This is my report.
Your Honor, at this time I would offer Case Exhibit 64. No objection. And I'd ask to publish it to the jury. Your Honor.
Slide with the 4 phone numbers that are included in the report and the date that the last edit was made onto the report.
Okay, so the top number, that would be the defendant's, right?
Correct, 5275.
That 910 number, the second from the top, would be that of her boyfriend.
Correct.
And the one below that, another 912 number, would be that of her brother, right?
That's correct.
And then the last one would be that of the child's father.
Correct.
Moving on to slide 2, can you tell us what we're seeing here?
Yeah, this is just an introduction that describes that methodology that I just spoke to you about. We take cellular records, tower list, and then the relevant date and times that are provided to us by investigators and produce a report using those data sets.
All right, moving on to slide 3, what are we looking at here?
So this is just a general picture of what a cell tower looks like. We've all seen them around. The most common one is going to be the one in the far right corner for me, the one that's labeled a monopole tower. That's the most common one, but it can also be a cell tower can be on the side of buildings. You would probably see that in the Savannah area. And then also based on certain statutes or regulations in certain cities or municipalities, they have to be hidden, but this is generally what cell towers look like.
Moving on to slide 4.
And so when you see that cell tower that's actually on the pole, a lot of people think of the pole or the apparatus as the tower, but the tower is actually the boxes that are on top of the poles. And in most instances, about 85% of all cell towers in the United States are configured in a 3-sector pattern. They could be configured in others, but by far the majority are 3 sectors. In this presentation, all of them are 3-sector towers. And what happens is the companies divide up the towers in those three sectors to service each side of an area. And they're generally divided in, you can think of a 360 degrees covers the full circle, and each sector is divided up into about 120 of that. So if you think of it as pie slices, like it's illustrated on this map, each sector serves that general area.
So this diagram is, we're above a cell tower looking down on it.
Correct.
Yeah, these little gray boxes here are the antenna arrays.
Correct.
You were seeing in the last picture.
Yes, sir. That would represent the actual towers, what's transmitting that RF frequency or receiving that RF frequency.
So each tower, 3 sectors, about 120 degrees each.
Yes, and in the records, the tower list that I referenced earlier, it will tell you the azimuth of that sector. So the azimuth is the direction that the center of that sector points at. So in this orientation, one sector has an azimuth of 0, which is true north. Sector 2 has an azimuth of 120, and sector 3 has an azimuth of 240. And once you know those, you know how to orient the pie wedge on your map to show which direction the tower's pointing.
And when a set of cell phone records says that a phone was hitting on a particular tower, does it also tell you which sector of that tower?
The cell phone records will, and you have to then refer to the tower list to find the orientation of each sector.
Slide 5.
So this is just in general narrowing down what you're going to see on the slide is one sector pointing towards the azimuth and covering that 120 beam width. We like to point out that the shaded arc is not the coverage area of a tower. It's just to help you orientate towards which direction that tower is facing.
Okay. In other words, the coverage of this sector doesn't end where the red shading ends. It's just a visual aid to show you which direction.
Correct. And it's helpful when you have multiple calls bouncing off sectors, so you know that these two were used and the third one wasn't. So
Slide 6.
So this is what the sector will look like on a map once we've determined that a call activity or network activity has happened on that sector. And we put it with the azimuth, and so you can see the general area. And what you also see on the maps are neighboring towers. So in this one, you have a tower here to the north, and we're able to use that sector and that beam width of 120 degrees in relation to the next neighboring tower and figure out a general area of where a cell phone would be located based on the tower coverage of that area.
Slide 7, timing advanced explanation. What is it?
So timing advanced is engineering data that the cell phone companies use to help optimize their network. So if you were to call in and say, I'm having problems with my cell phone, probably the first place they would look is the timing advanced data, and they would see when the cell phone is in your
Okay, I think they're back. So bear with me. Let's skip back to the other one then. They are back. So this is the Melody Walker Forest. So let me go back to this one. I was listening on this one, So this is the newly found evidence. This bit is that they're discussing now.
All right, what we got?
Judge, as you know, the state was made aware of some newly discovered evidence last week. The state informed the defense as quickly as possible of this evidence. We also informed the court of the evidence, and the state is now moving to admit that evidence for trial for the jury to hear by way of Captain Hands and Martha Jane Barton as witnesses. Captain Hands was already under subpoena. We have now confirmed that Ms. Barton is under lawful out-of-state subpoena. She's in Tennessee. And at this point, we can call a witness if you would like to hear more foundation.
All right, go ahead.
Captain Hands, state calls Captain Hands. Yeah, Your Honor, Captain Hands took a recording of Miss Barton when she called into CID, and towards the end of the recording, it's about a 14-minute recording from 12:10 to 12:30. Martha Barton gives her phone number, and we have been made aware by several witnesses that we have unintentionally put their phone numbers on the record and so forth. I think maybe the defense did to Mr. Ferris and then Addison Ferris and so on. So at this point, we would ask to redact that portion of the recording. It is 20 seconds, just her phone number.
Yeah, we probably have done some things in the trial with it being broadcast that we probably should have thought about, but we haven't dealt with that for 4 years, so.
Exactly, Judge. Captain, if you could please raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
How are you employed, Captain?
I am with the Cherokee Sheriff's Office. I am the Division Commander for the Criminal Investigations Division.
And can you actually state and spell your name for the record?
HANDS, just like the end of your arms.
Captain, were you on duty last week?
Yes.
Let me pull up specific dates and times. Are you under subpoena for this case?
I am.
And you were called out to, you were actually on scene in 2018 at Purcell Lane for this case. Is that true?
I was.
Okay. On Friday, October 18th, this past Friday, did you take a call at CID that you had to make our prosecution team aware of?
I did.
Okay, can you tell the court about that call?
It was slightly before 10 o'clock. My administrative assistant said that there was a Martha Barton on the phone, and she wanted to talk to someone that had knowledge of the case currently being prosecuted, the Melody Farris case.
So who ended up taking that call?
I did.
Why you?
I believe I was the only one in the building at the time that had knowledge of the case.
And so did you end up speaking with Martha Barton?
I did.
Did you record that phone call with her?
I did.
And have you had an opportunity to listen to that recording?
I have.
Did you forward that recording to myself, me?
I did.
And did you then inform me about who it was that just called and why you were sending me a recording?
I did.
And at this time, the state would like to publish, admit and publish M. Barton 1.
All right. For the purpose of this hearing.
For the purpose of this hearing, all right.
Have y'all got a copy of it yet?
We have it.
Okay.
It's 1409, Judge.
Captain Hands can I help you.
Who am I speaking to?
Captain Hands.
HAND.
S.
This is Martha Barton in Tullahoma, Tennessee.
How are you, ma'am?
Have you skipped the phone number?
Well, I've got a heavy heart.
Okay.
I'm sure you're very aware of the case of Melody Farris that's going on right now.
I am.
I've seen it on Court TV.
Mm-hmm.
I'm the person that she was coming to stay with in Tennessee.
Mm-hmm.
And did her mother and I were first cousins.
I think I
Her
remember
mother
your
was
name.
Pardon?
I think I remember your name coming up.
Well, it's been brought up in the trial too.
Yeah.
Well, Detective Hoke and Hayes came to my house along earlier the TBI came. They never asked me if we had any guns.
Mm-hmm.
Rusty Martin, that testified yesterday and the day before, is my stepson. My husband died 10 years ago. But he and I have had a close relation. He's been very good to me, offering to do things for me. And he's the one that had a relationship with Melody.
Yes, ma'am.
But they never asked me if we had any guns.
Mm-hmm.
And I thought that was very strange because my husband was a hunter. And we had a very large gun safe in the garage, but of course, they were never out. This may be long.
Mm-hmm.
I hope I don't go around the bush to tell this. But anyway, I think in 1979, we built in 78. I think it was in 1979 for Christmas that year. My husband gave me a 38 snub nose special. I never shot the gun. Roy went hunting. I never paid any attention to his guns. In fact, when we married, I was absolutely terrified of guns. And I guess I got over that a little bit, but never to the point of handling them and doing anything. When he gave me that gun, he gave me $100 bill rolled up and put in the cartridges.
Mhm.
And he made a joke. And Rusty was here. It was at our family Christmas, and he gave it to me. Said if he hadn't given me the $100 bills, he'd have never gotten away with giving me a gun. It was put in a drawer, different places. I even bought him a .357 Magnum. I couldn't tell you for Christmas one year. I couldn't tell you what that gun looks like, and it's in our safe. I couldn't tell you if it's chrome. I couldn't. I'm sorry. I just don't know.
Okay.
And if it were a purse or shoe, I could tell you. But anyway, the .357 Magnum, my husband was sick and at home when Melody came up to help us take me to Nashville to doctor's appointments. And at that time, Roy had gotten sick. Before that, because he had a stroke and he had Parkinson's.
You're talking about Roy, your
Before that,
husband, not Rusty, right?
Right.
Okay.
Before that, he had kept his .357 Magnum in his closet on his side of the bed. I mean, his closet's on his side of the room. And he had gotten mine out for me to keep on my side for protection.
Mm-hmm.
Now, I believe the shells, they were never loaded. And I think the shells to my gun were, I don't know if they were in my closet or not, but my gun eventually
Mm-hmm.
ended up underneath my nightstand because I just didn't like having it in my closet.
Okay.
And my closet is about like Deborah McGee's closet anyway. And so sometime after he passed away, Melody wasn't here at the time. And I don't know why I did not put those in the gun safe, but I didn't. There was in one of the spare bedrooms upstairs, there is a chest at the foot of the bed, but it's against the wall. And I put those two guns in there. I put a TV on top of it, and I don't even know what all, but I had stuff piled up on that I thought nobody is going to move all of that stuff to get in that chest. I was very weak one day when she was here, and I told her for several things were that I shouldn't have, but she had a way of, well, she was family. And I told her where those two guns were. Well, after she was arrested, I had someone come out and take a lot of things that I had gone through and stored
Mm-hmm.
in this particular bedroom, just in the floor and everything. And I wanted that TV all this stuff taken to Goodwill. And while he was here, I said, would you look in that chest and see about those two guns? and he did the 357 Magnum was there. My 38 Special was gone. I have also searched this house over to see. I mean, I know I'm not senile. I'm in very poor health, but that gun is gone. It was brought up in Rusty's testimony day before yesterday that his daddy had a 357 Magnum, and I almost believe that he said that I had the 38 because I was watching it, and the one that I was watching it on was the court TV, and there was a man down in the corner that would make comments, and he had the earphones on and everything. And when that was said, he said, that's where she got the gun. And I think that he would come, I think he called my name. My heart, I have felt so guilty ever since I realized my gun was gone. And then when it came up in court, I think that you all can go back and listen to that and realize that there is another gun. And another thing, it was in a little leather holster. And Scott found that gun, and she took that from my house. I was in the hospital 3 times, I know, from the time my husband died. I had heart surgery. And then I was in the hospital here in Tullahoma. I'm pretty sure it was 3 times. I know 2 times that my blood pressure dropped. And she was here, and she had access, and Rusty mentions in his testimony.
Okay, I can't talk about the testimony though because I'm under subpoena.
Okay, well, if you all can go back and listen to it, can you do that?
Okay. Now, was your gun in a holster?
Yes, it was in a holster.
Okay, a leather holster?
I guess that's
or...
one reason that I don't even remember if it was dark, chrome, whatever.
Who?
I'll check.
Okay, go ahead.
Pardon?
I'm so sorry, Miss Barton. Who was the guy that came over that you told to look for the guns after the arrest?
It was my nephew.
Okay.
But I really don't want him involved.
I understand. I am going to, and you've checked other places for the gun since. Is that correct?
I have looked this house over. That gun is not here. And there were some other things that I told her that disappeared when she was here too. That she is the only person. She was the only person in this house. So I don't have a family. I've got a niece and nephew, and we were split up over Melody too. It just about broke our family apart.
Mm-hmm.
Her coming up here, and I think they were in contact with Chris and Scott and knew about Rusty. Honestly, I did not know that was going on. It made me sick to listen to the testimony. I don't even feel like I can go out of my house. I don't get out that much anyway. But hold my head up in Tullahoma, because I don't know who knows this. I am so embarrassed.
Well, there's nothing that you did, so I mean, there's no reason for you to be embarrassed.
I know, but it's the Martin name. Well, I'm just sick.
What's your
I
phone?
didn't sleep.
12. I muted it. Replaying at 12:30.
The legal team that's currently prosecuting the case, so they may give you a call later today, okay?
Okay.
Would that be
I'll
okay
here.
with you?
Yes,
Well,
I'll be here.
I'm sorry for your heavy heart, but I do appreciate you giving us a call.
Well, I just felt like by not telling this that I was almost aiding and abetting. And I know from the get-go, she started throwing Scott under the bus.
Mm-hmm.
And I can't imagine a mother doing, I'm not a mother, but I cannot imagine a mother doing that.
Did she ever say anything untoward about her husband?
Pardon?
Did she ever say anything untoward about her husband?
Oh, she despised him.
Okay. All right. Well, I'm going to send your number and your information over. I wish you would feel good about walking around your hometown. You didn't do anything untoward or unethical, and you can't help the actions of other people.
Well, I know that, but I'm 84 years old and I don't need to be going through this.
No. We'll hope it'll be over very shortly, and we'll take it one step at a time, okay?
Okay. I appreciate it.
Thank you so very much, ma'am.
Thank you.
Bye-bye.
Captain, was that your complete conversation with Miss Barton?
Yes, ma'am.
Did you speak with her again after that phone call?
No, ma'am.
That's all I have for you. Thank you.
Just briefly, how did this phone call get directed to you?
My administrative assistant came to my office and said there's a Martha Barton on the phone that wants to speak with somebody that knows something about the case.
Okay. And that would be, you would know something about the case because back on July the 5th, 2018, you were actually in charge of this investigation, the entirety of the investigation.
Well, I would say the captain was in charge of the investigation and then the lieutenant was in charge of the investigation, but I was in charge of parts of it, yes.
Okay. And you assigned.
Oh, I'm sorry. Go ahead, sir. I apologize.
Well, there's been multiple witnesses testify that you gave them assignments in the case.
Surely.
Him included.
Surely.
So you assigned him as the lead detective of this case.
Correct.
Correct. So what involvement have you had in this case ever since?
Since when? Since July 5th?
2018.
Until we would do periodic hot washes, reviews of what we were doing, where things were going, what evidence was coming in. And since 2018, after the arrest warrants were complete, then it was pretty much just Detective Hayes, or now Sergeant Hayes, finishing his narrative and keeping in touch with the prosecutor's office.
You used a term of art that I'm not familiar with. You said hot watch?
Hot wash.
Hot wash. What is that?
It's basically a debrief, see where you are evidence-wise, investigative-wise.
Anything else for this witness, Michael? That's all, Judge.
All right, anything else?
No, Judge.
All right, you sit down.
Thanks, sir.
Have y'all had other conversations with her? Or
So, yes, Judge, our office did reach out to her. Investigator Moore spoke with her. She put together a report of a summary of their conversation, which we provided to the defense last week as well. And that was on the same day, same Friday at, let's see what time that was sent. That was later in the day on Friday, the 18th. I don't know how to get the.
It was 7:36.
Thank you. More information. Thank you. Yes, 7:36 p.m. Investigator Moore had sent her supplemental report regarding her conversation with Martha Barton.
All right, y'all got a copy of that?
We did.
Yeah, was any additional information disclosed in that?
So additionally, she kind of, Ms. Barton provided a timeline and stated that her, when her nephew came to help her, she realized it went missing around that time, which was in September of 2019. Shortly after the defendant was arrested. She also, She ended up telling her cousin, who is the defendant's mom, Kay Walker, about the missing firearm. She did not necessarily give an estimate of when she did that, but she stated that she ended up telling her about the missing gun. She provided that when Martha would speak with Melody in the jail, she would say, "I love you" to Martha Jane at the end of the call. And then shortly after telling her mother telling Kay Walker about telling Melody's mother, Kay Walker, about the gun, she stopped telling Martha, "I love you." She never confronted Melody about the missing gun. I think that was summarily the new information that we obtained.
And y'all have subpoenaed, effectuated services subpoena at this time, is that right?
Judge, I'm sorry, can we have one second?
Or,
We have some more information too.
all right,
We spoke with her again today, this morning, and I say we, Investigator Moore spoke with her again this morning, so she's gonna put together a report for that. But also,
y'all want to just
Put her on the stand now.
All right.
oh, yeah, Investigator Moore,
Go
sure.
ahead. All right.
We'll all find out together.
No, we know about
Yeah,
We don't.
if you could raise your right hand. Do you swear or affirm the testimony you're about to give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, have a seat. Please tell the court your role in the DA's office.
Yes, I am a SVU investigator, Monica Moore.
Are you assigned to this team here for the case against Melanie Ferris?
Yes, ma'am.
Have you been assisting putting the trial exhibits together and speaking with witnesses?
Yes.
Friday, the 18th, did you have the opportunity to speak with Miss Martha Barton?
Yes, I did.
And did you, after that conversation, put together a report and provide that to the defense
Yes.
defense attorneys?
Yes.
And did you have the opportunity to speak with her again today
Yes, ma'am.
to follow up with her? And
Also, the sound of theirs gone down. Just speak up a little bit louder.
Yes, sir.
what is it that she told you today?
Today she said that her niece Jennifer has been helping her because of her health issues, but her niece wanted to make sure that the gun was not in the safe. And so over the weekend, her and her niece came over and they checked the house over. They looked for it and they went into the safe and they found that the gun was not there, and that they also found some other items, some bullets that went with the 38 special bullets.
Okay. So the firearm, they looked for it over the weekend, essentially
Yes.
her and her niece,
Yes,
and they still could not find it.
correct.
Okay. Was there anything else that she told you that was new information from last Friday?
No, on Friday she did say she described the box of ammunition as red and white box with a TG and Y sticker on it. She remembers that her late husband bought it probably from that store up in Tennessee.
And that was in your report that you provided on Friday?
Yeah, but no new information after that.
Okay, that's all I have for you. Thank you.
All right. Swear, Mr. Ware.
Do you know anything about the manufacturer of the bullets? Does she have that information?
She did not have that information.
That's it.
Did y'all direct her to bring whatever she had with her after?
I have told her to just keep everything there and that keep it safe and yes.
All right, anything else from this witness?
No, Your Honor.
All right, you sit down, thank you. All right, anything else from the state on this issue?
I don't believe so, Judge.
All right. Argument?
We're asking the court to exclude. I expect you were. John,
You have a compelling reason. You have a compelling reason why I should exclude.
And honestly, I don't think you can exclude it right now. What else you arguing about? You already
Yeah, as we all know, normally when you violate the sequestration rule, typically what the court ends up having to do is just give a curative instruction to the jury at the end that it goes to the weight, not the admissibility of the person's violation. It's obvious from the audio recording that she did violate your court order, that she's not supposed to be watching it. My assumptions would be is that she has watched the entirety of the trial. Otherwise, she wouldn't know when Rusty was testifying, considering he was here, from my understanding, the entire week of last week and didn't even know when he was going to be called. He was essentially just at a hotel on standby to be available at any point in time. Under the case that I found this morning, it's State versus Brett Brown, and it is 354 Georgia App 493, the 2020 case. States that the court actually does have another option instead of just doing the curative instruction. It says that where counsel or the witness violates the rule intentionally, the court may strike testimony already given or disallow further testimony. The trial court's denial of a mistrial for violation of the sequestration rule is a matter of discretion and reversible only on showing prejudice. What ended up happening in the Brown case was there was a whole issue of whether or not the rule had even been violated at all, because it had something to do with two witnesses overhearing the judge behind closed doors. But that was actually never proven, and the court just ended up coming in and saying, I'm declaring a mistrial at this point, of which nobody essentially was requesting. Obviously, the defense was on board with it at that point, but the mistrial was overturned. The court, in making the statement that it is actually restrictable, was quoting the U.S. I think it's a Fifth Circuit case, Ferdin versus Llandysul Services, which is a 1993 case out of the Fifth Circuit. As discussed, and in that case it said there's no evidence showing that either the defense witnesses would have changed their testimony to match other witnesses. So it seemed like when you look at both of them together, well, actually, let me go into that part. So that was the Fifth Circuit case. The Brown case went on to state, instead the trial court should have chosen an intermediate option, such as allowing cross-examination of the witnesses regarding the possible violation and instructing the jury that a violation of the rule should be considered in evaluating their credibility. So that is that. Yeah. The way Millich
is interpreted out of the Brown case.
Is taking it out of the Brown case is that under the pre-2013 statute, the witness could not be disqualified for testifying as a result of a violation of the sequestration order. The new evidence code, although the sanction is rarely used, the trial court may treat a violation of the sequestration rule by citing the guilty party for contempt, allowing opposing counsel to cross-examine the witness as to the nature of the violation, or 3, striking the testimony already given or disallowing further testimony as the rule has been intentionally violated in actual prejudice results. I don't think there's any doubt that we would be prejudiced by this, considering we got this evidence on Friday. There's also another witness that she names in her recording, being her nephew, that he's out of state. We might need to subpoena him, but we're in the middle of the trial now, and this has now just become an issue, even though Ms. Barton has been interviewed now by law enforcement on 2 separate occasions. And the court can clearly hear from her interview, she actually does not come up with this new theory of the gun on her own. She said that the man on court TV, the one wearing the headset, said that's where she got the gun. And that's where she got the idea from. So her testimony between the 2 interviews has completely changed. She's never, and she freely admits that she's never told anyone about this gun being missing, even though she's known it's been missing for the past 5 years. So the state wants to bring her down here, put her on the stand, say Melody stole the gun, even though there's absolutely zero evidence of that. And in fact, if the court allows it, in her other interview, we're going to show where she was talking to Detective Hayes and Detective Pope, talking about, at length, about some boy who lived next door and was helping her husband and had broken into their house. So I think this, if there ever was a sequestration rule violation that needed to be excluded, this would be it. But I think, in all fairness, I think the court and Ms. Ferris's counsel will have to voir dire Ms. Barton to see what all she is going to say, because obviously that small audio recording is not all of it, to get to the bottom, especially of how she knew when Rusty was testifying, how much of the trial she has watched. Because my belief would be that she's watched the entire thing. She watched Scott's testimony, because there's actually some conversation in there about Scott and Chris as well that the court heard. So for that, we would ask the court to exclude Ms. Barton's testimony.
All right, Stokes.
Thank you, Your Honor. Counsel, the issue is whether or not there's been a violation to the degree that she cannot testify. Judge, the first thing I want to cite to the court is OCGA section 171610, and that's the code section that says both parties can rely on materials and information furnished in the discovery, so both sides don't have to turn over the same thing. 171610 also says that either party may call as a witness any person listed on either the prosecuting attorney or the defendant's witness list. We have listed her several times on witness lists, I believe, and also information going to the defense. We kind of kept her, we did not subpoena her, we kind of kept her, we talked to her before trial, and I think we actually talked about that if we needed her, we could do Zoom or something along those lines. So she was not under subpoena for us. I'm assuming, and I'll let the defense say if otherwise, that she was under subpoena for the defense. If she was not under subpoena for the defense or the state, then she's technically not in violation of the rule of sequestration. Now, I know, Judge, when we argue the law, sometimes we have to argue the technicalities and the precision of it. And so I think she would not be in violation of the rule. That being said, I don't think.
And
no, we
y'all had her on witness list, but had not.
Right, and they had her on her witness list.
Y'all had her on call, I expect, and
yeah.
talked to her.
And we talked informally that if we needed her, we would agree by Zoom. But Judge, I think so. She's not in violation of the rule. The second argument is that
there's the issue of one. It's new evidence that hadn't previously been disclosed. Then there's whether or not there's sequestration issue.
Yes.
All right.
The second statutory law, I'm going to get some decisional law in a second, but OCGA section 17164C, 17164C, and that is the code section that deals with newly discovered evidence during trial. We actually have a code section on it. It says, if prior to or during trial, a party discovers additional evidence or material previously requested or ordered, which is subject to discovery, and it goes on to say, such party shall promptly notify the other party of the existence. Judge, as soon as we found out on Friday, you may have noticed that we were sitting here in court, and we let them know and told the court we had some we went out and discussed it, gave them the information, gave them the recording, and we've been nothing but candid with them and prompt with them. So I don't think it's any violation whatsoever. And then there's several cases that talk about Williams v. State, 261 Georgia App 410, 2003. It cites newly discovered evidence is not in violation of the 10-day discovery deadline because it is newly discovered. Dixon v. State, 252 Georgia App 385, 2001 says no violation because the evidence was newly discovered and was revealed as soon as practical after its discovery. And in fact, the court in our system, as Your Honor knows, State v. Roberts, 247 Georgia 456, a 1981 case. The court, outside of all this newly discovered evidence, even if it was not newly discovered, that is the case, the Roberts case, they reopened the evidence during jury deliberations at the request of the jury. So the court has the ability to reopen evidence at any time and has that much discretion to do it. But when it comes to newly discovered evidence, it's a different rule, and there's been no violation whatsoever of that. And Mahogany, M-A-H-O-G-A-N-Y v. State, 366 Georgia App 750, 2023 case. So under the new rules of evidence, and it literally says, further, a violation of the sequestration rule affects only the weight and credibility of the witness's testimony, not its admissibility. That's Mahogany v. State, 2023 case. And then Park v. State, 314 Georgia 733, a 2022 case. It says, Park holds this. Supreme Court stated, a party's remedy for a violation of the rule is to request the trial court to charge the jury that the violation should be considered in determining the weight and credit to be given the testimony of the witness. When you when you look at this, I think there is no technical violation because they were not under subpoena, but in all candor to the court, she was a witness that could have been called by us. I do not think there's a violation that requires the court to charge the jury. I understand if the court charges the jury, there's nothing in this case to prevent her from testifying. And I know defense counsel has a job to do, and I know that this is evidence that should concern them. But I do not think they're telling the court that there's bad faith on part of the state. And the only way to cite counsel for the witness would be showing that there's some type of contemptible conduct by the party. And I can tell the court that that's not been done in this case. So I think they haven't, I think the court has great latitude and has, in fact, great discretion without it being newly discovered. But because it is newly discovered and has come in during trial, I asked the court to allow it.
Anything else?
Yeah, just to respond. In terms of it being newly discovered evidence, it's admissible. I mean, we're not really arguing that. We're arguing more the sequestration. If the court does end up allowing, what we're also going to be asking for is not for you to just charge the jury at the end, but prior to her testimony, state that, she was, you can fashion it however you want, but, something along the lines of, she was a potential witness. Witnesses aren't supposed to be listening to other witnesses' testimony, and it's going to be her testimony that she listened to other people. So that can go, to her credibility, or however the court wants to word that.
All right. And what y'all's plans to have her here Thursday morning?
Plan to have her here, I think, Wednesday evening, and have her here Thursday morning.
Right. Thursday morning for testimony.
And we'll be glad to make her available to you.
Yeah, I'd say I'll give y'all a chance to talk to her. Maybe we do that. I'll think about that.
We could have her as soon as 8 o'clock on it.
Yeah, that might be the
Thursday morning.
Yeah, I might have y'all.
I think the proper procedure is board iron. We have to do it.
Well, I'd let y'all talk to her, and then if we probably need to, may need to do the same thing with her prior to the jury with the evidence and let her testify as to what the evidence would be.
How much a motion to limit?
Yeah. And then if y'all want to present me a proposed charge, I'd consider it, although I may not. I'll look at that. But y'all definitely can cross her about all that and that she was a potential witness. And then whatever this other issue you said about whether or not someone else potentially took it, that's also something you could look in, question on. But I think based upon everything that's been presented, I'm going to allow it. I'll consider some sort of limiting instruction if y'all want to put one together and let me look at it. I'll consider that, and we'll talk about that more on Thursday. We could probably have the jurors report a little bit later on Thursday morning, give y'all a chance to talk to them, put it, whatever her testimony is going to be on the record prior to bringing the jurors in, go over anything else we need to discuss before we present that evidence, and then go from there. Although we have the afternoon plan at the moment. All right. Anything else?
So, well, we have one more issue.
Yeah. I provided, sort of to pick up where we left off on Friday, I provided both the defense and the court sort of a rundown of the digital evidence within Ms. Harris's presentation. I broke it down by, I think, the two main issues that the defense has, which is essentially what's titled geofence, but it's the Google location services. And then the second portion is the Apple Health activity. I think those were really the two issues that the defense had with the presentation. I outlined several cases on the memo that used Google location services. Ultimately, I guess to clarify, which I think was helpful even with me going through stuff, was the word geofence is actually the way that law enforcement provides the information to Google to obtain their location services. Geofence is not different than their actual location services on their phones and their apps. All it is closing it off to a certain location and a time frame. That's why it's called geofence. But ultimately, the Google location services use the same technology that has been around for a while. So GPS, cell site location, and also Wi-Fi. And all of those have been admitted in trials for a while. And I just cited some cases that specifically discussed the Google location services and some geofence warrants. Most of the cases when they come up are in a framework of a Fourth Amendment issue, a motion to suppress issue. There weren't a ton of cases outlining the reliability of it. However, it's 1C, the amicus brief by Google. Google filed an amicus brief in a case that I think was very helpful. It considered, they referenced Carpenter, they referenced all of these cases that are a bit more specific to the Fourth Amendment, but in that amicus, they discuss how it works and why it's reliable, and that it really just uses the same technology that we have been using in our phones and in our cars and so forth. And it describes that kind of when you pull up Google Maps, shows your location in a blue dot. And then if it's not as certain of the exact location, you'll see like kind of a blue circled hue around the dot. And so once your connection gets better, kind of the hue goes away and you see your location. And so it describes that and why it has, when you get a return for the Google location services, it has that radius, and that is the certainty of the actual location of that device. And so I'll move on to the Apple Health activity. That is a little bit more novel of a case, of technology, but I did find a 702 analysis in a case. And so I cited that is United States versus Riego. It's a 2022 case. And it was a circuit court. It was not an appellate court, but it applied the 702 analysis for an expert witness. And so the court held in that case, and you can read it, I quoted the case there, Judge, that the defendant was arguing that the testimony is unreliable because the witness was unsure of when and who at the FBI monitored and validated the UFED system, that's Celebrate. Basically, they did what we did here, Judge. They pulled the activity information from the Celebrate extraction, from the cell phone extraction, which is what we did. And then they had a presentation through a digital forensics expert. And they basically just validated the monitored and validated the UFED system, which was Celebrate, and was unsure about how the application that counted the steps worked. But in other words, apart from knowing that the FBI monitors the system to ensure it's working properly, French did not know whether the system was working accurately in the day he used it to analyze the data from the defendant's phone. Nevertheless, this point affects the weight of the testimony rather than admissibility and can be brought out on cross-examination. It does not render the opinion unreliable. Regarding the health application, French, the witness did not know the specifics about the operation of the application, but his intended testimony is solely regarding the technical knowledge and data that was pulled off the application from the UFED and Celebrate system. to the extent the inner workings of the health application are relevant, such points can be brought out on cross. So essentially, it's the same role as Ms. Harris would. She would just be communicating the data to the jury in an understandable manner. So,
All right. One of the things I thought about over the weekend, in the middle of the night when I think of things like that, we talked about, I brought up toxilizer, and then over the weekend I thought about an Alka sensor. Now, we all know the Alka sensor spits out a number. Alka sensor being a roadside personal breath test device. The number is not admissible in court because the device, even though it spits out a number, is a scientific device and is not inherently reliable. It's not tested. It's not calibrated. It's a portable breath test that, because it's floating around somewhere in the car of the police officer, is subject to variables. And that's even a device that, is approved for use on the side of the road. And so again, I don't know. We all think we know how it works. We don't really know how it works. I have a better idea maybe than others, but I still don't know how it works. It still goes through Apple's filter and their proprietary information. And so I still think I need to hear more evidence if y'all are wanting to get that data presented to the jury. I might, in thinking about it in that term, comparing it to Alka sensor, I might let the witness say that based upon review of the data that was collected, that there was some activity. And that might be, that's better than saying no activity, but I'm still not 100% about that yet. But
sure, and to that point, Judge, and I can proffer this, the testimony about her activity is pretty general. It would be, she had more activity on this night than a year's worth of, and it was an outlier. Right. We're not getting into sort of like, well, she climbed this many flights, so that means she went up and down the stairs that many times. It's not that specific. It was just an outlier.
Your report does have that. So that's probably where
Okay, so the presentation is just the outlier graph.
Right.
So to the point of what would she be presenting in her presentation, it is a very general outlier scenario. Sort of like the phone calls with Rusty that we were able to point out. Well, Ms. Harris was able to point out, they didn't speak at this time ever. It's sort of the same concept, just statistically speaking, comparing her own activity with her own activity.
I think that is probably more in line with what would be appropriate without going to specific number of steps and specific number of flights and that kind of stuff. But again, I still, if you got, I know you're looking and still trying to find more information, and I'm willing to, let y'all keep plugging away at it.
Can I clarify with the court, or have the court clarify?
The Google stuff I'm fine with.
Okay.
I think that's
okay.
Or I think that is certain, and it gives specific, it is submitting and pinging back a specific, latitude, longitude point, and then has a variable around it. And so that, shows the margin of error, if you will.
Sure.
So I think that is appropriate. And I believe that has reached the level of scientific certainty that is appropriate to be presented in court.
Okay. And can I just have the court clarify? So the data itself within the phone, within the extraction, the phone that gave us the data with which Ms. Harris is providing to the jury, that part is stipulated to. So I guess I'm not sure what the court is looking for when it comes to the data itself, as far as the functionality of it.
Well, y'all, whatever you think you can get to convince
Okay.
me. But
I do have, I guess my second question would be, if I have that information with Ms. Harris found a study that was done, she is not comfortable testifying about that study. Okay.
that's part of the problem is we don't have someone who can testify to me as
Right.
to its scientific reliability.
Right, which could definitely be a subject for cross, and I understand that. Is that something that the court is interested in, that type of article?
The more you can give me, the better
Okay.
it is. But I don't, like I said, I don't think that there has been a case that's really utilized it. Part of it depends on what you're trying to do.
Sure.
If you're if your ultimate, what you're trying to get in is that she was on her phone and she's walking around, I think that's okay. I think
Sure, so,
it's when you want to say she walked half a mile or she went up and down 12 flights of stairs.
I
That's-
can tell
Those
you.
slides in their presentation.
Right, correct.
Well,
So
there's, I believe there's one slide that provides the distance that the phone provides.
Right.
The testimony we obviously have to provide them the data that we got, right? So that would be that.
That would be kind of like,
But
so
what-
similar to the Alka sensor. So the officer on the stand knows what the number is, but can't testify to the number.
Unless it's open.
So-
The door's open.
Correct.
Sure. So Ms. Harris, ultimately, that number, whatever the number says it is, when pulled a year's worth of her activity from just 1 hour, 11 p.m. to 12 a.m. every single day, there are only 3 times, right,
That she is
Level of
more active on
activity.
that day than she was on that day.
exactly. And so that is essentially the purpose of pulling the number. So if the court is more comfortable with us leaving the number out and just stating the outlier dates, I mean, we're happy to do that and carve it out to the court's comfortable.
I think that is something that I think your witness could articulate that.
Sure.
But I'll still give y'all a chance, but I'll still let you give me some more information and give y'all a chance to revisit it before we get to it.
Yeah.
If you could, we have a copy of the case we'd like to present to the court. That would be Albright v. the state, 354 Georgia Appellate 538. That would be Albright versus the state, 354 Georgia Appellate 538. That's a 2020 case. And it kind of actually is the only thing. Most of the cases that Ms. Frankish has noted in her memorandum, and everyone knows Ms. Frankish is very diligent with her legal research, but they're all circuit court cases in federal court from all over the United States, but not really local to the state of Georgia, maybe the Trump case to some degree. And then a number of these cases on Apple activity.
I don't think that was ever testified to or admitted from.
Oh, it's just.
Yeah, no. I mean, it
it's
was
just
brought up. But I don't think it ever. It was brought up. I don't think it was ever addressed by the court. I don't think the court ever heard that evidence. And it's on appeal, and I don't think that evidence was ever presented. But that was also a totally separate sideshow issue, not having anything to do with the criminal case and the actual evidence against the defendant that was pending. So I mean, I know you're arguing against it, but I'm also, that's the reason why it might not be.
Sure. And then moving on to the Apple Health activity, it's just, South Carolina versus Murdaugh and all these cases that aren't really, there's no sites for these cases, and it's not founded science. That's the point. Even within her own research, it becomes very clear. And I have to disagree. I believe the issue on Google is not a founded science either, if you look at the cases that they cite to. And I do have this Albright case that kind of discusses Pinlink. And ultimately, the Court of Appeals can't get anywhere because the primary issue in this case was discussing ineffective assistance of counsel primarily. They can't get past that. But the court did limit the use of PinLink in that case. And so therefore, after the inquiry that this court was taking, I think it should take under consideration what the Court of Appeals has had to say regarding PinLink.
Yeah. Well, kind of going back to what we talked about earlier today, you presented the CPAP data. Using that as another analogy, had you tried to present evidence of some medical issue based upon that data, I would not have allowed that so using that same, because that wasn't reliable source would be my concern there. But the activity, I think, is a different issue, and that it was being used, and it was being used on or about these times. Now, if you tried to say it was specifically being used at this time on this day, that may be a different issue. But the fact that it was generally being used overnight on those days, and there was activity every day or every evening until the night that it wasn't used, I think that's an appropriate use of that data. So I guess in that regard, I'm probably using, a 403 limitation on it, but it's a very interesting issue and, very right. And I think it's still evolving. And so y'all keep looking and we'll keep talking about it.
And just from Mr. Weaver's argument, he talked about different cases and certain cases. Under 24.104A, the court is not bound by the rules of evidence. And then under 24.7702F, for the Daubert standard, we are
Right.
specifically to look at federal courts.
Right.
Is the court fine with us? If we do, we'll copy the defense, of course. If we come up with some studies, maybe.
Everything that y'all can give me, I'll happily look at it.
Thank you.
Thank you, Judge.
All right. Anything else we can take up?
I don't believe so.
Oh, one thing, I'll probably be late tomorrow. John Luke will be here. I'm going to be at the office working with our staff members on some of our cases.
Okay, that's fine. All right, we'll be in recess till the morning.
Hang on then. Oh. Bear with me, people. Well, she's going to do a for Dyer, and then it might come up. And then, yes, probably he is inclined to put it in. Yes, he said. Andrew Burkhardt, trying to think, there's a few of them that are not covering live because there's no live thing, obviously. Oh, there you go. Mexi's got it. Oh, it might be Superior Court. I don't know which one. There's a letter from the powers that be that posted to Howie Carr because he asked for clarification, and they responded back by saying, yeah, she's finishing, but she will still be doing the Karen Reid trial. Yeah. So, yeah, that's all I know. I'm not 100% sure where it's come from. What? No, I love Andrew Burkhardt as well. She's probably one of the best ones out there. I think, yeah, she's. I wish I was like 10% as good as what she is. So right, I know we're supposed to be doing this trial, people, but I'm trying. I just can't do this Leilani thing one. I'm pushing myself too much here. I just feel like I'm gonna be sick if I because there's like another 4 or 5 hours. Oh, fucking great! Your video can't be monetized. But yeah, fuck off. Fucking hell! If it's fucking one thing, it's another. Raining fucking cats and dogs. Because of my intro, for fuck's sakes. Sure, she's definitely hot mama. She's definitely hot mama. Definitely. Andrew Burkhardt. Meow. I'm not saying I will never stream this trial because I might do when we got if the judge is right and we got like 2, 3, 4 days of testimony in this, I might play it, but I encourage you to watch somewhere else. I feel like I'm pushed it too far. I feel like I put like 8.5 hour stream today. I think I just pushed it myself a bit too much. So yeah. So I'm not going to cover it. I want to cover it because I feel like I'm letting him down a little bit, but I'm going to burn myself out. So, thank you everybody. That's very kind of you. So you watch it somewhere else. Obviously there's lots of other places to watch it. As I say, I might play clips of it somewhere if I get them during downtime and stuff like that. But I just don't feel I can give it I'm playing, and the worst thing is I'm playing at 1.5 speed, which is not great quality for you guys. So I'm trying to rush it, and I just can't rush it. I feel like I'm letting him down. I'm letting Quinton down, I feel. So I don't know, I'm gonna think of something else. So yeah. Oh, Grizzly's covering it. There's quite a few people covering it. Covering it. To be fair, I was shocked. There's more people than I thought would be covering it. There's less people covering the other trial. The other trial we're definitely covering, no doubt. Yeah, Joe, I don't disagree with you. I've been intrigued to see if there's any clips. So sometimes Law Crime do clips of interview, like testimony. So I might play them and stuff. Oh, Grizzly won't mind. No, thank you, Ro. Thank you, darling. It's fine. Yeah. Anyway, so yeah. Anyway, people, I'm gonna leave it like that because I'm gonna have to now dispute this claim as well. Which great. Love you all. I really do. I'll be back at 8:30 tomorrow. Hopefully, nothing else will go wrong in between. Oh, thank you, Carol. Hang on. Thank you, Carol. That's lovely of you. Thank you, my darling. That's made me smile. Thank you, darling. Hang on. Carol, I'll get there now. I'm just feeling a bit slow. Oh shit. 7. Carol Dreamer bought 7 coffees. Thank you, Carol. And thank you, Tut, this morning. 7 is for good luck. Get some rest. Love you, Dylan. Thank you. Love you too, Carol. Thank you, my darling. I really appreciate all of you for that. And Carol, you're always way too generous to me. But thank you, my darling. I appreciate that. And Tut this morning, Robin G and Deb as well for the gifted memberships as well. Thank you, everybody, for kind generosities. I really do appreciate it. I'm Mexi now as well. Thank you, Mexi, who got some memberships. Zoe, Matty Cakes, Samantha, Sheba B, and Jen Doe Gus. Congratulations to all of you as well. And thank you, Mexi Texi. That's 20 memberships going out today. So thank you very much. Heather Taylor just leaving. So, my darling, I'm sorry. We're leaving now. I'm not covering this anymore. I haven't got enough time in the day, and I'm going to burn myself out, and I don't want to burn myself out. But what that does mean, people, is that means I can actually do some more members only, probably start next week. I'll try, do weekly members only on one night a week then after hours, So yeah, I need to do more members only, but I don't have the time at the minute. Just in time, no, Heather. We are just winding down for the day. We are. Dylan, are you sure you're okay? Even your speech seems affected at the moment. No, I think I'm all right. I just tired, I think, more than anything. Not sleeping well, and just one of those things. Not the greatest day today. It's one of those things, you don't like to get copyrighted. So yeah, I don't know. Not feeling the best. But no, thank you though, Joe. I do appreciate that. No, I feel okay. I do feel okay, my darling. Thank you very much. Thank you. There you go. Worry about it. Thank you, Joe. Hopefully I'm okay. Thank you very much, though. Mexi, gotta get some vitamin D. What's vitamin D? I think I do. Is that calcium? Make sure that's on the Apple app. I will. I think I take vitamin D. I take a tablet. I take magnesium and I take something else. I think it's vitamin D. I think I take vitamin D in the morning, I believe. So I'll be much better after this sleep apnea goes. So sunshine, hey sunshine. But yeah, thank you everybody. Sorry for letting you all down again. But I'll see you at 8:30 tomorrow morning. You are a dunce, but we love you. I don't know what she's on about, so I'll ignore that. Thank you, everybody. I'll see you tomorrow morning, 8:30 in the morning. Take care of yourselves and have a great night. Take care. I'm pressing end now. End stream. End stream.